I look at the decision by Judge Torres as a prime example of what I've been saying, not just me, but others, that we got lucky. Today's topic really is to address what XRP holders has known for over 2 years, and that is the SEC is coming after all of crypto. We had a hearing earlier today, and it was involved the fact that Grayscale is suing the SEC, and we know that Coinbase has now launched an initiative to try to all address the fact that we are at war, a war that was declared. Unfortunately, a lot of people didn't pay attention because they let the SEC engage and divide and conquer, and that war began on December 22nd of 2020. Now, we predicted this. I'm not going to stand up here and say I told you so, but XRP community predicted this war, and it's now against all exchanges. We've seen the Kraken situation. We know that Coinbase has released the fact that they have received subpoenas, investigative subpoenas. I'm getting a call a week from entrepreneurs who want to talk to me about the fact that they're under investigation and they're expecting Wells notices, or they're being asked to sign statute of limitations, tolling agreements, because the SEC is coming after them. And we're talking about projects that range from a couple $100,000 raised to multi-millions. And even we see cases that involve fraud have unnecessary language. A lot of people made a big deal about this that green mining machine case that was filed. It really is just a fraud case, but ask yourself, why does the SEC, when it's really a deception and misrepresentation and fraud case, why do they throw in there that's general language that it's also unregistered securities? Why in the Wowie case that it was insider trading and fraud? Why do they then say, oh, these 9 ERC20 tokens are also securities? And so the point I'm getting at is that all token holders are now realizing what XRP holders have been realizing for the last couple years, and it is time to end the tribalism. It's time to come together and let the best technology win once we have a level playing field. Now let's talk about briefly, because a lot of you want to talk about obviously yesterday's hearing. This case, the Ripple case, as Charlie brought up today on Fox Business, the result in this case is going to dictate a lot. Okay, and what I said was that if the SEC wins and XRP is deemed a security, and the judge doesn't distinguish secondary market sales, and she doesn't distinguish the token itself, and all of those things, if the SEC gets a flat out victory, then you can bet that that is going to be used as a hammer against every other token, including Ethereum. And I don't care, I was laughed at and other XRP holders were laughed at when we talked about the fact that Ethereum was going to be implicated potentially. Okay, sorry for the background. Again, I'm on Fox Green Room. Things are happening. It's live TV. What can you do? Now, what was so monumental about yesterday? I looked at this order that the judge came down. Everyone needs to know the SEC has 5 experts. Ripple has 10 experts. It's a Daubert motion. It's basically each side trying to preclude the other side's expert witnesses. The huge victory for XRP holders in generally, and a little bit for me personally, was that expert number 1. Remember the guy that the SEC said, we're not going to let you XRP holders come in this case and tell us what you think and what you were thinking and why you bought XRP. Did you buy it for an investment? Did you buy it for non-investment uses? Do you use the XRP ledger? Do you use the DEX that's part of the XRP ledger? We're not going to let you. We're not interested in that because we got a guy that we hired, paid $3 million to give him a contract in his firm. He's going to come in and say what XRP holders believed in their mind when they acquired XRP. And as many of you know, I filed a motion asking to file an amicus brief addressing that. I highlighted the fact that this guy, and Ripple did as well, that this guy had never interviewed one single XRP holder in his entire career. And at his deposition, a thread of mine, which was summarizing what the 3,500 declarants, XRP holders that signed affidavits, and we sent that to the court, we sent that to the parties. My thread summarized that, why people bought XRP, and he was cross-examined at his deposition. And at his deposition, he conceded. He said, well, I didn't know this, and I don't know any of that, and it may have changed my mind had I known it. And so that caused the SEC to not even use him at summary judgment. But the big deal now is, if there is a trial, if there is a jury, he will be precluded from ever testifying to what you or I were thinking when we acquired XRP. And so that was a huge victory. I said a little bit of validation for me, because that was the motion where they asked to throw me off the case. They said because I disclosed his name, that somehow I whistle called for people to harass him. I'm not mentioning his name now. Even though Ripple had identified SEC experts previously, although the SEC had identified Ripple experts, but as we all know, they lost, and they lost big on that. I look at the decision by Judge Torres as a prime example of what I've been saying, not just me, but others, that we got lucky. This judge applies the law impartially, without prejudice, and that's this decision showed. I view the overall decision as a 60-40 victory for Ripple, but a couple of the rulings were big. The two biggest rulings in our favor for XRP holders was what I already mentioned, which was expert number one not being allowed to testify to what you or I thought, or what we were relying on, but also, and this is a shout out to all the developers that signed the affidavits. We submitted over 50 affidavits of independent developers who never received money from Ripple, who never received any grant money. People like Jay from Spin the Bits signed affidavits, and their expert was precluded from claiming that if Ripple were to move and never work on the XRP ledger again, the XRP ledger would fold. It would basically cease to exist or function, whatever. That's in essence what he was going to say. And the judge precluded that. She basically said she's not going to allow him to testify to that kind of testimony if there's a jury trial in front of the jury. And I think that's significant, because it does go to show you that even though the judge doesn't cite those things in her opinion, they had an impact on the case, because you had developers developing on the XRP ledger independent of Ripple. And so that was a big deal. But the judge, it wasn't all for Ripple. Ripple lost some things, but these are reasonable situations. The judge, for example, is going to allow the SEC's expert. A lot of you feel strongly about this, and are going to be upset maybe, but the SEC expert says that his testimony is that when Ripple made announcements, the price of XRP was impacted and it went up. And therefore, that goes to show you that XRP holders were relying on the efforts of Ripple, blah, blah, blah. Ripple challenged that and said, listen, this guy took very small sections of dates and tried to extrapolate, and that's improper. And the judge said, that's for you to argue in front of a jury. If it goes that far, that goes to the weight of the evidence, not the admissibility of the evidence. And so basically the judge also, for both sides, said, you make valid points about your criticism about the expert. They said that to Ripple. They said, this expert that you're challenging on the price of XRP, these are valid criticisms, but I'm not going to prevent him from saying it. You just need to do your job and do a good cross-examination if it goes that far. And so I can tell you the main thing to take away is that this ruling showed that XRP holders and what we've done and what we fought for has impacted the case. And we prevented somebody from speaking for us because we spoke for ourselves. So for the 76,000 that signed up, for the 3,500 affidavits that people took times out of their day, they got them notarized, we got them submitted to the court. You should be proud of yourself, because you didn't just sit around and complain. You said, I'm going to do whatever I can to join the fight, and it worked. And so, one big reasons for this brief live cast is because the summary judgment decision's coming. I said I think it's going to come within a couple weeks. Some people believed, as I said on Fox today, that the decision might come together with the experts and the summary judgment, because some judges, including Judge Torres, has done that one time in the past. And so that's why I said we're probably a couple weeks or shorter from getting the decision. Now, I could be wrong. I could eat these words and it could take another month. Who knows? But I think you have to prepare yourself, though, for not, I guess, resolution, in the sense that I read this decision and I already went on record to say that there is a chance that there's going to be a jury trial. And I think that has increased. For example, what could this Judge Torres say that needs to be decided? Usually in a library case or other kick case or these other cases, if both sides agree on the facts enough, the judge can decide it as a matter of law, and there is no need for a jury. But if there's too much conflicting evidence, then a jury needs to decide which evidence is more credible and more reliable than the other side. Battle of experts, for example. But here's an example. The SEC does not have an expert to say what you or I were thinking when we acquired XRP. We have an amicus brief filed that talks about non-investment use of the XRP ledger and how XRP is being used for payroll, XRP is being used to substitute fiat, XRP is being used for cross-border remittance, peer-to-peer off the XRP ledger. All of those things that we discussed, the judge could say that the SEC's motion for summary judgment is denied because they didn't prove their case at summary judgment, and now they have to prove that there was no non-investment use for XRP. And so therefore that whole issue could be something that has to get tried.